February 4th, 2026. Good to have you here. Trust you can hear me okay. Glad to have you here. This is Helps YouTube Live. So what Helps is a national law firm. Our main mission is to protect seniors from debt collector harassment. Okay, and we do that under a law called the Fair Debt Collection Practices Act, passed in 1978, that provides if you're represented by an attorney, debt collectors can no longer call or send you demand letters anymore. So when people find out about us, the enrollment helps. We send out a letter to your debt, the people you owe money to, uh, and tell them not to bother you anymore. If they have any questions, they call us. And so, most common thing I hear from my clients is that peace returns to my life. Okay, so that's what we do. Uh, and then our second mission is to educate seniors how they can maintain their financial independence, and that's the main reason we have YouTube Live, Monday through Thursday, and that's where you're at right now. So if you have any questions, you can put it in the chat feature. You can also look at our webpage, www.helpsushere.org. You can always call us on the phone. We're here to help you. We're here to answer your questions. And you're probably going to get answers here that you're not going to get other places, because there's a lot of misinformation out there for seniors. Not too many organizations tell seniors the fact that their Social Security or that their pensions are protected. They don't do that. Why don't they do it? Well, if they were to tell you that your income was protected, you need to pay the debt. You wouldn't pay the debt. They wouldn't make money off you. So that's why. So first person contacts us here. I'm looking at a note, someone from Oregon who's 65. They were referred to us by, it says Lawyers Referral Network. Now I know who that is. He says they were a godsend, not just rescuing me from a fraudulent company, but then referring me. This is a company that refers people to attorneys to file bankruptcy. But if they find someone that doesn't need to file bankruptcy, can't afford to file bankruptcy, maybe it's a senior citizen, their income's too low, they'll refer them to Helps. He says, I'm actually at below poverty level, but have always been tried to keep pedaling to stay up. But yes, I'm desperately looking for help. I have been for years. But I never got anywhere, even though I'd spent hours on the phone going to places that were supposed to be helpful, and no, not so much. There's so much to add here, but I'm thinking perhaps wait for the question first, and then I'll fill you all in. Thanks so much. Kind of a nice little email that guy sent us, or note. And our note talked to us yesterday, and it says that our paralegal says that this person was almost deaf, but has implants that helps them speak on the phone. They get Social Security and food stamps, has a little savings left from her parents passing. She is currently using that savings to subsidize paying for housing, rents, and owns a car outright. She has credit card debt she can't pay. We read what we did and enrolled her in Helps, and explained to her why she doesn't need to pay the debt anymore. She can use that money for her needs, for her food, for her medicine, for the things she needs. That's what Helps does. We take the pressure off you from the creditors harassing you. Okay. And then we take the pressure from the creditors harassing you. You give us the creditors you don't want to pay anymore. We need their name, address, and account number. We don't need the balance you owe. And then we send a cease and desist letter, and they're going to leave you alone. And it's easy to enroll in Helps. You just do it over the phone. We don't turn anyone away. The cost is minimal, and in some cases it's free. We want to be able to help people. Remember that when you enroll in helps, you can stop paying this credit card debt you can't afford to pay anymore. But let's say, for example, you have a credit card with a small balance that you wanted to keep. Well, you could keep that credit card as long as it's not backed by a bank with whom you have another credit card you're not going to pay. So yes, it is possible to keep a credit card. And then a lot of our clients aren't worried about rebuilding their credit, but if you are, we do have a program called 7 Steps to a 720 Credit Score, where after 90 days in helps, we can send you a link. You can enroll in a program that's free to help rebuild your credit. You can rebuild your credit within a year and a half to 2 years. Okay? And this program helps you do that. So this person contacts us from Illinois. They're 68 years old, and they got credit card and medical debt. And we told her about a cease and desist letter. Apparently, they said they wanted to try doing that on their own, which they could. And we explained what we did. That was on January 16th. And then they called back on January 20th. Um, and she wanted some more information about the cease and desist letter. We told her where to find one. And then they called back, looks like maybe today. She got, it says here, she was served with legal papers and stressed, especially since she's undergoing chemotherapy. And we read her what we did, and it looks like she decided to enroll in helps. That's the nice thing about helps is, we take the entire burden off of someone. So if you do get sued, and it's possible that, if you enroll in helps, you could get sued for one of these debts. That happens. It's probably less likely because when you enroll, we send a letter to the creditors who you owe money to, let him know your income's protected. But sometimes they don't read the letter, and sometimes they just want to sue anyway for the sake of it. So if they sue, we call you and explain why you don't need to go to court. We're going to send a letter to the attorney who sued you. We're going to let that attorney know that your income is protected. We're going to remind you about the protected nature of your income. And back in 2012, Congress, there was a rule passed that affects banks. And what it does is it instructs banks that if they get a writ of garnishment, they're to examine your bank account. And if federal funds were deposited in there, they're supposed to take the amount that was deposited in the last 60 days, and they protect that. So it's usually your Social Security times 2. Or if you got a federal pension or railroad worker pension or post office pension, those are all federal pensions. Social Security times 2 is protected automatically from garnishment by your bank without you having to do anything. So a lot of times we'll tell our clients that are sued or there's judgments against them to keep one bank account, that's the account to which their Social Security goes, and to try to keep the balance less than twice the amount. Now, if you happen to have more than that in there, you should be able to get it back by filing a claim of exemption or challenge to garnishment with the court. But if you keep it less than twice the amount, your bank will protect that automatically without you having to do anything, which is kind of nice. And I always explain to people, your bank manager doesn't understand that rule. I've yet to talk to one who does, but there's a department in the bank that deals with garnishments. They understand the rule. Okay. Now, what about an attorney? Do they understand the rule? Well, not too many of them do. I've always said that 1 out of 1,000 understand the rule, and I pretty much still believe that. There's not many that understand the rule. Why? They don't deal in this area. That's why. But just because you're an attorney doesn't mean you know everything. Not by any means. Attorneys specialize in certain areas. Okay, and then when you specialize in an area, you concentrate on an area, then hopefully you get to know that area. Okay, person contacts us from Alabama. I got a collection letter from Chase. Lost his business last year, 79 years old. Lost his business last year due to health issues and is no longer able to pay his debt or her debt. We went over what we do, and she wanted to know if she should respond back to a letter request a payment plan. And we explained to her, you don't have to do that. All your income is protected. She didn't have enough money to make a payment on a payment plan. She had enough to take care of her basic needs, and that was it. She asked, should she send something to the creditors to let them know that she's not lying about the income? No, you don't need to do that. We sent her some emails that explain about helps and what we do. We have 400 or 500 emails on different topics that we can send to people. Some of them we send more often than others. And we sent her some bunch of emails about helps and what we do. We sent her a general email that has a link to our webpage and our YouTube page. We send an email that talks about YouTube Live, an email that says who can helps. And then she called back on February 3rd. And we signed them up with helps. So hopefully they're going to feel better because they're not going to have to worry about these creditors harassing them anymore. Doesn't have to, they're not going to be able to harass him. So if we have, I've explained this before, if we have 5 people that contact us for helps, maybe 1 is being sued, 3 or 4 are being harassed, and 1 is current on everything. It doesn't matter where you are. If you've come to the realization that you can't afford to pay the debt, you can contact us, even if you're current on the debt. You can stop paying it. If you're signed up with a debt settlement or debt management company, and you hear me talk about this a lot, the question I'm going to ask you is, when you signed up with them, did they tell you that your income was protected? You didn't need to enroll with them because no one could take your income. If the answer is no, which it normally almost always is, you weren't given complete information. If they would have told you the truth, you would have realized you didn't need their help and you didn't need to enroll with them. Let alone telling you that there's a way to stop the creditors from bothering you. So, yeah, if you're signed up with debt settlement or debt management, you can stop paying them. You can call them on the phone, ask them to refund or to return any money they're still holding for you. Guy calls us from New Jersey. Husband is 70, the wife is 69. And the husband was calling, he says, on behalf of his wife. He says, we have a situation. I look forward to talking to you. Sorry for calling late. We'll talk to you tomorrow or next week. Thanks a lot. This was way back in June of 24. And he says, well, Best Buy is suing them for a credit card. We went over what we did and the options for the lawsuit, and we sent him a bunch of emails that he read. Then he called a year later, back in March of 25, a year ago. Now he's 70 years old, calling for my wife. Had some more questions that we answered. And he called. We called him back a few times in April. Then he called back on January 9th of this year, just a few weeks ago. We're going over the same problems they had. Current on some debts, stopped on others. Explain what we did. Then they called on February 2nd, which would have been what, Monday? And then called again yesterday. And they enrolled in helps. But, they first started calling us way back in, June of 24. So a year and a half ago, which is not unusual. No, we don't want people to enroll in helps unless they feel really comfortable about it. And sometimes people think they can try to struggle out of their problems on their own, which is fine. But if you're at the point where you realize you can't do that, and you're cutting back on your needs, there is a solution. You can stop paying the debt, and we can protect you from the creditors bothering you. This is HS. When getting a check from a company that owes you money from a breach of your personal information, will that be protected from judgment of creditors also? Well, if you deposit the check, first off, practical matter, no one's going to be able to garnish the money, the company that sending you the check. They would never know about it. They'd have to have a judgment, know about where the money is, and know that you're being paid that money, which is never going to happen. Okay, second off, you get the check, remember twice the amount of your federal benefits in your bank account is protected, no matter where they came from. Come from another source. So if you got a check for $2,000 and you got $2,500 in Social Security, $5,000 is protected in your bank, $2,000, as long as your balance is less than $5,000. Now, if you got, but then you don't even need to worry about this unless someone had sued you and gotten a judgment. Now, if you got an extraordinary large amount, it depends on state law. I suspect under a lot of states that kind of check would be protected. But there's things you could do. You could cash the check. You could endorse it in someone else's name and then have them cash it. And then there's ways to protect the fund. So I wouldn't be worried about that kind of thing. I mean, you can worry about it, but there's an answer for the question. Okay, so small town ask. He's in Arkansas, and apparently Arkansas Protective Services taking care of their mom, taking control. And they're worried when mom passes away, who's going to control the funds? She was not on Medicaid, and they used her own retirement and Social Security to pay her nursing home. Well, okay. Technically, yeah, if she's on Medicaid or not on Medicaid, and they've taken over, they're going to use her own funds until those funds run out. Then at that point, she'll go on to Medicaid. So if she dies before the funds have run out, then no, the will takes in effect, and the property is going to be distributed under the terms of the will. And whoever's the personal representative, the will is going to take over because the state is no longer involved with the mom since she's deceased. So this person contacts us from Iowa. He's 69, had a stroke. And we talked to the wife. He gave permission to speak with his wife. He has communications issues due to the stroke. And he stopped paying about 2 years ago and was served with a lawsuit It's like last week. We went over what we did, and he enrolled with HELPS, with his wife helping him. So, yeah, we help a lot of people that have medical issues and help a lot of people with strokes. I know all about strokes. My dad had a stroke when he was 58, passed away when he was 74. I helped take care of him for, 16 years. It was really, really difficult for him. Very active man. And then was put in a wheelchair, for the last 16 years of his life. Um, so I know, and before that, I didn't know anything about strokes. Strokes can be really tough. If you get a stroke on the left side, it affects the right side of your body. And so that's what happened to this person. They had a stroke on the left side, affected the right side because the right side controls your brain controls your speech. Okay. And so his speech was affected. Now my dad had just the opposite problem. The stroke was on his left side, so it affected his uh, um, on his right side, so it affected his left side. And speech isn't one of it. If anything, it made him my dad more precocious. But yeah, we talk to people that have had strokes, and there's all kinds of different series of strokes. And the nice thing about Helps is that when you enroll in Helps, it's not a one-time thing. You're literally our client forever. So if you ever have a question or concern or worry, you pick up the phone and you call no matter how often. That's why Helps was designed. It was designed so that we would be able to help people ongoing. Okay, we don't represent you in court because you don't need to go to court. If you got sued, get us a copy of the lawsuit. We send a letter to the attorney that sued you, let him know that your income is protected. Call and tell you why it's protected, why you don't need to go to court. And then if you ever have a question or get other paperwork you're concerned about, you get a copy to us. We'll go over it with you. So one thing we tell people is if you call and you say, I didn't want to bother you guys because I know you're busy, and we are busy. No, uh, we don't like to hear that. If you're worried or concerned, you pick up the phone and you call. The fact that we're busy has nothing to do with it because we can answer your questions, give you assurance so you realize you don't need to worry. Okay. Person contacts us from Georgia. They're 71, and they say they have some debt that's current, some that's not. A couple loans with finance companies. And we reviewed what we did, quoted the fees, and they're ready to enroll. And then a note says that the finance company used a riding lawnmower as collateral for one of the loans. I'll explain that. I've explained it before, but we always have new people listening to the channel, and it's kind of good to know. Some finance companies, and a lot of them in the South, I think Georgia's in the South, they use what's called a non-purchase money security interest, which is a type of loan where you list certain property out and give that property as you get to use it, you own it, you control it, but you give it as collateral. So if you don't pay the loan, the lender can come pick up that property, supposedly. And I've said this before, I'll be 75 here real soon. Okay. Um, and 46, 47 years of practice, however long it's been, I've dealt with a lot of clients that have had, purchase money security interest. I don't recall an event wherever a lender came out and actually picked up the item. Now, they may threaten to do that, and that's the reason they have these loans like this. Is they use it as leverage to make you think, gee, if I don't pay this loan, they're going to pick up my lawnmower. Well, the lawnmower isn't worth that much money, and if you didn't give them permission to pick it up, if you had it parked in your garage or in your backyard where they didn't have access, they'd have to file a lawsuit. They don't do it. And a lot of times the stuff they use as collateral might be, a couch or a love seat or a bed or dining room table, whatever, or a TV. Sometimes the TV's now broken or you gave it away, and sometimes it's years old. They just don't do it as they don't go after this stuff. Okay, now that's called a non-purchase money security interest. So I wouldn't worry about it. So Super Cinema asks, how many years can the credit card and collection agents keep coming after me for all them with the huge balances? Well, um, in some ways I could say there's no time limit, but there is time limits for certain things. They have to they have to file a lawsuit within what's called the statute of limitations for the state where you live. That might be 5 or 6 years, could be 3 years, could be longer, but usually it's 5 or 6 years for the state. And usually that's under state law, that's from the time when you either incurred the debt or you last made a payment on the debt. A lot of times it's when you last made a payment. So if you have a debt that's 5 years old and you made a payment last month, they might have another 5 years to file a lawsuit. That's a statute of limitations. Now, if it's beyond the statute of limitations where they legally can't file a lawsuit, they can still contact you. Okay, try to collect the debt, but they can't, they don't have any, there's no punch to their call. Okay, they can't file a lawsuit. I mean, not legally anyway. I've had people call me that have been contacted by creditors that are 15 and 20 years old about that debt. And I've often spoke about a letter I read not that long ago. At the last paragraph of the letter said, by the way, we can't really do anything about this because the statute of limitations, we can't sue you, but we'd like you to make a payment. And then the problem is in some states, I think if you made the payment, it might start up the statute of limitations again where they could sue you, but it depends on the state. But once again, if your income, Social Security, or pension, if you get sued, they can't really do anything. You're judgment proof, so you don't need to worry about it no matter what. But it is a fact that once a debt gets pretty old, they're going to leave it alone. But maybe the lender, whoever owns the debt, might sell it to a debt collector who might try to bother you and might take advantage of someone not knowing or understanding the law. Okay. Person contacts us from New York. They're 68 years old. They get $1,400 in Social Security, $900 in pension. And the son helps out by sending $240, I think it said, every other week. We read her what we did, and they enrolled with helps. She has a credit union, and we told her that, well, if you have a credit, she has $100 in the savings account. We explain if you get sued, then you're going to want to get rid of that savings account or just keep the minimum amount, because if your Social Security goes into your checking account, that's the account that's automatically protected, not your savings account. And it looks like she was being sued by Citibank, and it's set for mediation. Apparently she had asked for mediation or she had filed some paper, but it says she will not now be attending that since she's spoken with helps. We emailed her the email that we call, do I have to go to court? Which explains why you don't have to go to court. And we also sent an email that is called, what happens when a helps client is sued, explains the process. And we also sent an email about debts, the hidden trap of debt settlement. She's been paying a debt settlement company $550 a monthly for over a year. Wow. That was, yeah, almost a quarter of her income. She says they're now holding about 600 of her funds, but they haven't really helped her. She's going to cancel them and request a refund of the funds they're holding. Yes, can do that. She says they're set to take a payment out on the 15th. She wants to take care of this and contact her bank. You can call them on the phone, tell them not to take it out. If you're worried about it, you could contact your bank and put a stop payment, or you could just make sure there's not any money in your bank account for them to be able to take out on the date they say they're going to take it out. She's going to email us a copy of the lawsuit, and then we're going to send a letter to the attorney who sued her. Let him know that her income is protected. She's not going to pay the debt. She doesn't have a home, and she's leasing a vehicle that she wants to keep making payments on, which is fine. And the last sentence is a very lovely lady that was so happy that what we can do for her. Yeah, all our clients are lovely. And it's going to take a lot of pressure. It's going to take pressure off her son. He doesn't need to send her $240 every other week, because mom doesn't have to pay that debt management company $550, which she's been paying them over a year. She'll be fine. She doesn't have to pay their other debt she has either. And she doesn't have to worry about the lawsuit. I talked to someone, I don't know, a couple days ago. A lawsuit was filed against them, and they had filed an answer, and a court hearing was set. And they were almost dead determined that they had to do something since they filed that answer. And I explained to them, no, you don't need to do anything. I said, when we send a letter to the attorney that sued you, we're going to let them know that your income is protected. You're not going to do anything. Well, what about the judge? Judge doesn't care. That attorney is going to, there might be a hearing set on your case. You're not going to be there. The attorney is going to tell the judge that he got that letter from you, and the judge is just simply going to award a default judgment. So what? They can't collect from you. Okay? So no, if you file an answer to a lawsuit and you realize that I owe the money, you owe the money, there's no defense to it, you don't have to subject yourself to the humiliation of going to court and having the judge saying that you owe the money because you owe the money. You can just forget about it. And if you're a member of HELPS, you get us that information, we send them a letter, they're going to leave you alone. One of my credit card accounts has been sold to a collection company. Should I be concerned? Well, that's most of our clients that enroll in HELPS. The debt they owe has been turned over to a collection company. So no, if your income is protected, Social Security, pension, disability, like I've explained, it doesn't matter who owns the debt now, whether it's the original creditor or a collection company, or for the fact that you've been sued. Doesn't matter. What's important is the fact that your income is protected, no matter who has the debt, or no matter what arrangements you made to pay the debt. Doesn't matter. You can stop those arrangements. Just because someone sued you and got a judgment, and then you made an agreement to pay them $100 a month, you don't need to do that anymore. You can stop paying it. What's their remedy? They can try to take money from you, but they can't because your income is protected. Like I've explained, you don't need to worry about it. Okay. If the statute of limitations is expired, does the creditor know this? And what does HELPS do if they file a lawsuit? Well, they pretty much know it. If they were to file a lawsuit, technically you have a defense to the lawsuit, but you can't just sit back on your hands and do nothing. A person would have to file an answer alleging the statute of limitations having expired as a defense to the lawsuit. But that could be a headache for a lot of senior. Hey, it's been statute of limitations is 5 years. It's been 7 years ago since that debt was incurred. Now they file a lawsuit. I have a defense to statute of limitations. What do you do? Well, if you do nothing, they get a judgment. They can't collect from you. Okay, they can't do anything. They can't touch your. You could still choose to ignore the lawsuit. If they get a judgment, it's meaningless. You could defend yourself on the lawsuit. We don't run into this very often. The problem is for the debt collector, if they file a lawsuit after the statute of limitations and it can be shown they knew that, and they would know that, then you could file a counterclaim for violation of the Fair Debt Collection Practices Act, and they'd have to pay attorney fees. So because of that, it's not a problem of them suing people after the statute of limitations. And if it was, you would have a defense. Uh, we don't represent people in court on that kind of thing. Um, but no, there wouldn't be a problem if your income's protected. Okay. Person contacts us from Missouri. They got sued for a credit card debt. The age is 56. Um, they're concerned about a judgment and the creditor being able to take his Social Security. No, they can't take your Social Security. And we informed him that while we cannot prevent a judgment being issued against him, his Social Security is federally protected. We went over what we did. Can we send a letter to all of his creditors? Yes, we can do that. What if he cannot provide all the names of the creditors? You can give us what you know, and you can add in others in the future. A lot of, we don't need them all at once. So if another creditor pops out of the woodwork that you forgot about, you didn't know about 6 months from now, get us that. We'll send a new cease and desist letter. Or if the collector or the creditor that has the debt sells it to a new collection agency, you get a new notice a year from now, a year and a half from now. If you get a demand note, get it to us. We'll send a new cease and desist letter out to that new debt collector. He said he's interested in our services. He'll review the emails that we sent him. And we sent him some more information on January 26th. And then he called back on February 2nd. And then on February 3rd, apparently has a lawsuit with a summons with a hearing date or on the February 18th. Doesn't need to go to that. Enrolled with helps. He was married, but he just enrolled by himself. But the last note says that we may add his wife in the future. So sometimes people will enroll with helps if they're married. Only one of them enrolls. But if the spouse that didn't enroll with helps later decides they want our help for whatever reason, we can add them into the file. There's no extra charge. We just add them in. It's easy for us to do it. We'll send letters to your spouse. We'll send letters on behalf of the spouse that enrolls later. Okay. Person contacts us from Texas. They're 67. It's $1,442 in Social Security and $330 in a pension. They rent where they live and has an old car. It has two Capital One debts that he accrued after a medical procedure. He's now in collections. And it says he's begun to receive lawyer advertisements for certain case number. So a lot of attorneys that practice bankruptcy will send an advertisement letter advertising bankruptcy services to people that have been sued. They subscribe to a service that lets if a lawsuit's been filed, and they'll send out a letter to anyone who's been sued in the geographical area where they practice, saying, hey, you've been sued. If you need our help, you can file bankruptcy, blah, 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 blah. So that's why he's getting those letters. Some people get multiple letters. Anyway, we enrolled it. They call us on the phone. We sent them a bunch of emails on different things. Who can helps, the cost of helps, a YouTube channel, why you don't need to worry about a lawsuit, and we enrolled him. And then he's going to get us the lawsuit information. We'll send a letter to the attorney that sued him, letting him know that he's not going to go to court. Now, he may not have been served with a summons yet. He just got these letters from the attorneys that file bankruptcy. In that case, we tell people, don't worry about it. Let us know when you get served with a summons, when someone knocks on your door and serves you the paperwork. Because that's really when it starts. In other words, a lawsuit can be filed, but the timing doesn't really begin until someone actually gives you the paperwork for the lawsuit. Okay? So this person calls us from I don't know where. Says they're very confused, thought she was calling someone else. She still wants to speak and get some help. She gets Social Security and has debt and found us on Google. This is back in 22. Oh, this is interesting. She called a few times in August of 22. She was in a debt management program, got sued. They're filing for a default judgment. She was paying them $250 a month. Yeah. She has a little student loan debt. We sent her a bunch of emails. She lives with her daughter and rents a room from her daughter. She wants to file a response to the court so the judge knows what she's been through. The judge doesn't know about that, doesn't care about that. One thing's interesting is that in most jurisdictions, the vast majority of lawsuits that a judge deals with are, at least lower level judges, are lawsuits for debt. And the judge's only duty is to say you owe the debt. He's not in charge of trying to collect the debt. So let's go. So she called again a couple years in May. So she talked to me, and I said that she's still a little bit confused and doesn't want to involve her children. That was May of 23. And then she called again Monday, it looks like. 78 years old from California. She detailed her struggles with the debt management company that took her money without proving necessary services. She's feeling overwhelmed and seeking guidance on how to handle her debt and harassment from debt collectors. So we finally got through to her on February 2nd. Lives with her daughter and her son-in-law. Doesn't have a car, credit card debt, medical debt, and she's got an ongoing medical condition that's pretty serious. Was in debt consolidation, but has since exited the program. And the paralegal says that she is a very kind person. She offers very long answers to the intake questions. We read what we did, enrolled her with helps. My only wish is that she would have enrolled with us back in 22 when she first heard about us. She wouldn't have had gone through the last 3 or 4 more years being harassed by creditors and having to deal with these issues. Oh, so if you're listening to me now and you're having these problems, understand that you can always call. You can call right now. There's someone there answering the question. 855-435-7787. And when we enroll people, it helps. We do it over the phone, so you can be enrolled immediately. What is the cost? The cost is minimal. Most a person would pay would be $40 for 24 months, $20 for 24 months, free thereafter, or $30 for 24 months, $15 for 24 months, free thereafter, or $20 for 24 months, $10 for 24 months, or free thereafter. But we don't turn anyone away. Some people get our help for free. And then they give us the creditors you owe money to. We're going to send a cease and desist letter. You're going to be our client ongoing. So if you ever have a question or concern, you can always call. We don't want you to worry. You pick something else to worry about, because there's always something to worry about. But the debt, you don't need to worry about it. Okay? And once again, if you're involved with debt management or debt settlement, and they never told you what I'm telling you, you were given incomplete information. So Robert asks, I'm a member of HELPS. I've been over a year since I stopped making my credit card payments. You sent a cease and desist letter on my behalf. Well, I haven't. I've been sued yet. Well, that's the whole idea of HELPS, is that it makes it less likely that you would be sued. When we sent a cease and desist letter out to your creditors, Robert, we told them your income was Social Security, you couldn't pay the debt. And if they would have looked at the file and they would have had any brains in their heads, they would have realized suing you would be a waste of their money. Now, I used to give people a certain percentage of clients that would get sued, and it was pretty low. But I don't do that anymore because, like I've explained, that you could get sued by more than what I was saying before. You could have 10 creditors and maybe all of them sue you. I doubt it. Okay, but it doesn't matter how many sued you. If you get sued or not, your income is protected. You're not going to have to go to court. You don't need to worry about the debt. So I'm not surprised that you haven't been sued. And then sometimes it may take them longer than a year to sue. Maybe they're going to turn it over to a collection agency. And maybe the collection agency might decide 2 or 3 or 4 years from now that they're going to file a lawsuit to collect the debt. Okay, depends. I'm being harassed by a company called, it's a debt collector. And they have called my children frequently, and me too. They have my phone number, email, and address. I told them to send me proof of the debt, and all I get is the amount. Tired of their harassment. So would you please get involved and send them a letter about my fixed income? Thank you. I suspect this is an existing client we got this from. So we're going to send a cease and desist letter out to this new debt collector so they leave her alone. Person contacts us from Ohio. My wife passed away, and with it went her retirement income. I have a lot of, that's not always the case. Sometimes, when you retire and you've got a pension, there's different ways you can take the pension. You can take it in full till you die. You can provide that you get a certain percentage of your pension, and then at your death, your spouse gets half. Or you could take a lesser amount, and when you pass away, your spouse keeps getting that amount. He goes on to say, I have a lot of credit card debt, and I struggle to pay it. I'm currently with a debt repayment plan through Freedom Debt Relief. I just requested they reduce how much I pay into each month so I have money for my medical needs. Boy, I haven't heard that. I would like assistance in dealing with credit cards, with creditor calls, emails, and text messages, and have someone I can refer them to when they ask for a phone number and name. Can you help me? Yes, we can. First thing we tell you is to get out of that debt repayment plan. It's not doing you any good. It's flushing money down a toilet. Don't need it. Okay. So this person writes in, they want to know, sorry, if I decide to stop paying my hometown credit card, do I need to close my checking account with that bank? My social security check and small pension are deposited in that checking account. Also, my son's name is on it. My answer was, if it's a credit union, definitely yes. Technically, a bank under the law cannot offset money from your checking account to pay a debt owed to the bank if only Social Security is deposited. Other money being deposited could open it up to the possibility of being offset, although that is rare. The exception is Truist Bank. They're like credit unions. They'll take money out of your account if you owe them and don't pay it. Person calls us, South Carolina. They turned in their travel trailer a couple months back. Um, and looks like it's gonna be auctioned off here real quick. It says they're on Social Security and they can't afford it anymore. I'm 72 and my wife is 70. Don't need to worry about it. You know, when they auction it off, they're probably going to sell it for less than what's owed. Once in a while, there's an exception, but very rarely. Uh, and then they're going to send you a letter for the difference. It's called a deficiency notice. And then uh, if your income, Social Security, or pension or whatever, you don't need to pay it. If you're enrolled with HELPS, you're going to give us that letter. We're going to send a letter to the lender you owe the money to on the balance on the RV or the travel trailer in this instance, and they're going to leave you alone. Okay? Is Truist Bank governed by a different kind of law that they can go into your account and take money like credit unions do? No, it's the same law, except they don't they have decided to kind of use the same stationery store as credit unions do, which means that when you sign up for an account with them, whether you realize it or not, you gave them permission to take money out of your account, no matter the source of funds that came into there, to pay a debt that you owe the bank, Truist Bank. Normal banks don't do that. Truist Bank does. They started doing that a couple of years ago. We discovered it, and so sometimes we'll mention Truist Bank. Now, if you bank at Truist Bank and you're part of HELPS and you don't owe them any money, you don't need to worry about it. It's only if you owe them money and you decide not to pay Truist Bank. Okay? Person contacts us from Texas. I'm 71 on Social Security and have a state pension. His wife also gets Social Security and a pension, same age. Due to some medical expenses, etc., he's going to return a car I was making payments to. Both of our Social Securities and pensions are deposited directly. Understand that these incomes are protected from garnishment or bank liens. I also work part-time and deposit into a different bank. Would it be better off depositing my part-time wages in the same account as my Social Security to protect that account in the funds? You don't need to do it right away. If you're sued, you probably would want to do that, and then you'd want to keep the account into which your Social Security is deposited, less than twice the amount of your Social Security you get each month. That way, if they were to happen to garnish that account, if you got, let's say, 2,000 in Social Security, you and your wife had one joint account, you got 2,000, she got 1,500. That's 3,500 times two would be 7,000. Would be protected from garnishment. So yeah, you would probably want to have your wages go into that account. Now they can't garnish your wages directly, but they could garnish it out of a bank account unless it's deposited into a bank account uh, that is protected under twice the amount of your Social Security that's in there. Okay. Now, if you happen to have it in another account, probably could get it returned by filing a challenge to garnishment or claim of exemption, and you explain to the court or show the court where the money came from a protected source like your wages. But you can prevent having to do that by just keeping the balance in your account less than twice the amount of Social Security you get each month. Okay. So it's been almost an hour. Next questions are pretty long. I'm going to call it quits for today. If you have any more questions, you can put them in the comments, or you can also call us at the number below. Tomorrow will be the same time. Okay. Don't want you to worry. I want you to have a good day. And if you are stressed about any of these issues, please don't hesitate to call us. Okay. That's what our job is, to help seniors deal with these debt collector problems. And we can help you. I promise that. God bless and have a great day.